Hi everyone, this is Amber Holloway and I'm a partner here at our Troy office, and welcome to the April 2023 episode of My PIP Monthly. Our April topics will include a case law update. We only have one this month, but it will be the case of Briggs v. Knapp, which is an unpublished opinion from our Court of Appeals, which was recently issued on March 9th, 2023. And then I'll move on to some trending topics in PIP litigation. As I said in last month's episode, we received a couple of requests, so this is one of those. And we're going to touch on a discussion of the 1-year back rule in general and the 1-year back rule pre and post no-fault reform. All right, moving right along to the case of Briggs v. Knapp, again an unpublished opinion from the Michigan Court of Appeals issued March 9th, 2023. The biggest takeaway from this case is that a defendant must produce some evidence through the video or data showing that an accident was unavoidable to claim the sudden emergency defense. In this case specifically, a police officer testimony and lack of citation alone were not enough to trigger the sudden emergency doctrine. Litigation here stemmed from a negligence suit brought by the personal representative of Amari Bell against defendant Jeffrey Knapp, and that was for a breach of common law duties and statutory motor vehicle violations. Here, the plaintiff was in dark-colored clothing and a pedestrian on the side of the highway at night when he wandered into the right lane and was struck by defendant. Plaintiff at trial produced evidence that prior to the accident, two individuals called in to report that plaintiff was on the freeway. Plaintiff also relied on its expert, who noted that other individuals were able to see plaintiff and that defendant could have taken precautionary actions such as cleaning the headlights and using his high beams of his vehicle. Ultimately, defendant filed his motion for summary disposition based on the deposition testimony, police investigation, and plaintiff being more than 50% at fault for the accident, and lastly, the sudden emergency doctrine. Ultimately, the trial court denied defendant's motion, finding that there was an issue of material fact, relying heavily on the fact that two other drivers were able to observe plaintiff, those two other drivers that called in prior to the accident. A little bit more background on this one. The defendant did deny responsibility for the accident, and a field sobriety test revealed that he was sober at the time of the accident, but defendant was driving home from class, driving around 70 miles per hour with his standard headlights on. He was not talking or texting on his cell phone when the accident occurred, and defendant also testified that he never saw plaintiff until after the collision occurred. Defendant also denied having any opportunity to avoid the accident as it was dark out. There was no ambient lighting. Both the accident reconstructionist and investigating officer concluded that the plaintiff was at fault for the accident, comparing the situation to a deer strike. Defendant also noted that plaintiff had controlled substances in his system at the time of the accident. So ultimately, in one of defendant's main defenses, they argued the sudden emergency doctrine, that the accident was just unavoidable, essentially. On appeal, defendant claimed that there was no genuine issue of material fact due to the plaintiff wearing dark-colored clothing, lack of light, and inability to avoid the accident. Now, we all know to establish a case of negligence, a plaintiff must generally be owed a duty by the defendant, that duty must have been breached by defendant, and 3, damages must have been suffered by the plaintiff, and lastly, that the damages were caused by defendant's breach of the duty. Generally, whether a defendant owes a duty of care to a plaintiff is a question of law for the court to determine. Again, this case kind of hinges on the sudden emergency doctrine, but generally that applies when a collision is shown to have occurred as a result of a sudden emergency, not of the defendant's own making, and that's the case of White v. Taylor. The sudden emergency doctrine allows defendants to avoid liability regarding events that are completely unexpected, but it is important to note that that instance must be completely unexpected. Regarding the duty owed to pedestrians, they are to 1, make proper observation as to approaching traffic, 2, observe approaching traffic and form a judgment as to its distance and its speed, 3, continue his observations while crossing the street and highway, and 4, exercise a degree of care and caution which an ordinarily careful and prudent person would exercise under like circumstances. Now, regarding whether defendant here owed a duty to plaintiff, the court held that defendant had a duty to look out for pedestrians. Turning to whether defendant breached that duty, the court held that there were issues of credibility regarding whether defendant could have seen plaintiff prior to the accident, citing that those other two drivers did indeed see the plaintiff. Further, there was an issue of credibility as to whether defendant was looking at his phone or was distracted at the time of the accident. Thus, it was up to the jury to determine defendant's credibility. The court then addressed defendant's assertion that plaintiff was comparatively negligent by wearing dark clothes, walking on the side of the highway at night, and being intoxicated. The court did note that plaintiff's clothing and timing did not alleviate the duty owed by defendant. And further, regarding intoxication, the toxicology report did not establish that plaintiff was actually intoxicated at the time of the accident. Finally, the court turned to defendant's arguments regarding the sudden emergency doctrine. The court noted that if defendant was distracted at the time of the accident, then he cannot claim the sudden emergency doctrine because he created the situation. The court then addressed defendant's arguments that all of the police officers testified that the plaintiff was actually at fault for the accident and defendant was not issued a citation. The court noted that defendant's vehicle did not have a data collection box and did not have video evidence supporting defendant's claim that the area was dark and he was unable to see plaintiff. And again, we have those two other callers that called in that said that they did see plaintiff. And also the court noted that the officer's determination that plaintiff was credible did not remove the issues from the jury. Alrighty, moving on to trending topics in PIP litigation. Here we have what is commonly referred to as the one-year back rule, or MCL 500-3145. The title of this section, it's a limitation of actions for recovery of personal or property protection insurance benefits, periods of limitation, tolling, and notice of injury. Now, pursuant to Section 1, an action for recovery of personal protection insurance benefits payable under this chapter for accidental bodily injury may not be commenced later than 1 year after the date of the accident that caused the injury, unless written notice of the injury, as provided in subsection 4, has been given to the insurer within 1 year after the accident, or unless the insurer has previously made a payment for personal protection insurance benefits for the injury. So, in lay terms, you cannot bring an action more than 1 year after the date of the accident unless written notice has been provided or unless the insurer has made a payment. Section 2, subject to subsection 3, if the notice has been given or a payment has been made, the action may be commenced at any time within 1 year after the most recent allowable expense, work loss, or survivor's loss has been incurred. However, the claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date on which the action was commenced. Pursuant to subsection 3, a period of limitations applicable under subsection 2 to the commencement of an action and the recovery of benefits is told from the date of a specific claim of payment of the benefits until the date the insurer formally denies the claim. The subsection does not apply if the person claiming the benefits fails to pursue the claim with reasonable diligence. 4. This one describes the type of notice. Notice may be given to the insurer or any of its authorized agent by a person claiming to be entitled to benefits for the injury or by someone in the person's behalf. The notice must give the name, address of the claimant and indicate in ordinary language the name of the person injured and the time, place, and nature of the person's injury. So the proper notice has to contain those things. An action for recovery of property protection insurance benefits may not be commenced more than 1 year after the incident or accident. Now, all of that is essentially the 1 year back rule. But post no fault reform, the 1 year back rule is told from the date a specific claim for payment of the benefits until the date the insurer formally denies the claim. This does not apply if the person claiming the benefits fails to pursue the claim within reasonable diligence. So now we're going to start seeing more and more litigation as to what's reasonable diligence. Is reasonable diligence a call? Is it an email? Does that reasonable diligence have to have all those notice requirements within it? Or is a call with a claim number enough? And then there's also the issue of pend versus deny. Or suspension versus denial. And again, we'll start to see more and more litigation regarding these types of denials or types of, I wouldn't even say denial, types of discontinuing benefits to a claimant. Whether it's you want to pin the benefits, whether you want to outright deny or suspend. But from my experience with this issue, a denial is always the best form of discontinuing benefits, because there can be no mincing of the words or trying to get around what a denial really means. And I did also want to note that reasonable diligence wasn't necessarily an issue pre-reform, and neither was the pending versus denial type issues. Now, what we're starting to see in a lot of, for example, provider cases, is that although litigation has taken place with the claimant's claim, like the claimant has their own PIP claim, because there hasn't been a suspension of benefits, providers are alleging that the 1-year back rule doesn't apply because there's been no formal denial of the benefits. Even if they haven't provided notice of their bills, they're claiming that because there has been no outright denial of the underlying claimant's claim, that they can pursue those benefits whenever they want, and that's simply not the case here. They are still subject to the 1-year back rule, but again, it's always better to pursue that denial or get a formal denial, especially if a case has or if a case is in litigation. I've seen cases go on for, second and third generations without a denial because the plaintiff is simply filing suit because of 1-year back issues. Now it goes into litigation, but still you have those providers that may pop up a year or two later and say they're not subject to the 1-year back rule because there was no denial. So denial, I have not seen any situations where, an insurer has regretted a denial, or as a defense attorney, I've regretted seeing a denial. Of course, an adequate denial with the proper medical examination. But that just seems like the best way to go to protect insurers all the way around. And that is all I have for you guys for the April 2023 episode of My PIP Monthly. As always, please feel free to contact me with any questions and/or concerns. Thank you.